Oh, it says it's now streaming live.
Getting. Okay, Wendy Murphy, how are you?
Good. Nice to see you, Peter.
Nice to see you. Thank you so much for joining us on Marcy's Law interview series, Why We Do What We Do. I know you are about as busy as a lawyer and a person can be. And I really appreciate you taking the time to be with us today. You have been probably one of the most recognized victims' rights lawyers in the country for over a decade now. I want to just go a little bit through your bio. It could take us the whole 30 minutes, but I'm just going to go through it right now, just a tiny bit of it. You're a former prosecutor, which is how we got to know each other a long time ago. Prosecuted child abuse and sex crimes for many, many years. And for more than 15 years, you've been an adjunct professor of sexual violence law at New England Law in Boston, where you also co-direct the Women's Law and Children's Advocacy Project under the Center for Law and Social Responsibility. In 1992, you founded the first organization in the nation to provide pro bono legal services to crime victims. And your work in state and federal courts have really changed the law to better protect the constitutional and civil rights of victims, especially women and children. You've been referred to, and I want to get this quote right, as no pressure, the best talker on television, with a finger on the pulse of victims and women's rights. And you've worked for NBC, CBS, CNN, Fox, and you've appeared on every single other TV station that's on regular cable, DirecTV, and every place you can see streaming television as well. We've known each other, like I said, for decades. And I have watched really with awe and respect for the way that you treat victims, the way that you advocate for victims, and the way that you conduct yourself and the professionalism with which you conduct yourself in a courtroom. You never, ever back down. And you know, I think when a judge, I know when a judge walks into a courtroom, everybody says, and the court officer says, all rise. And I used to say that when Wendy Murphy walks into a courtroom, people turn to each other and whisper, this is going to be good. So with that, I just wanted to welcome you. And you have done so many different things and advocated for victims on so many cases around the country. I wanted to focus on a couple of cases of yours that really became groundbreaking and landmark cases in the area of victims' rights. We will talk about how each of them relate to the importance of constitutional rights for victims as opposed to just statutory rights. And then the whole idea that elevating victims' rights to a constitutional status doesn't necessarily do anything, and doesn't do anything to diminish the constitutional rights that a defendant enjoys in the United States and state constitutions. So having said that, you were involved in the very first case where there was a recognized right for a victim to be heard.
Yeah, it was I didn't know at the time that it was going to be the first case in the nation. I knew it was absolutely the first case in Massachusetts because it came pretty soon after I stopped being a prosecutor, which is to say, I knew as a prosecutor that there were these victims' rights laws out there. And I also knew as a prosecutor that no one was doing anything about them. No one was trying to enforce them. And so they were there, but they didn't have any meaning. And I, as a prosecutor, certainly couldn't take responsibility for enforcing them. So as soon as I left the DA's office and started to focus on doing work for victims, it was in part because I was intrigued by what those rights meant. What could we do with them? And when I left the DA's office, it was partly because I was so frustrated with all the horrendous things that were happening to victims, and no one seemed to care. No one seemed to be doing anything about it. And I would object and complain about it and, tell the judge that he or she couldn't do something that they were doing. Because I thought it was so clear that the rights of especially women and children were being treated differently than the rights of other kinds of crime victims, robbery victims, eyewitnesses to carjacking, whatever. That if it was an abuse of a woman or a child in particular, the court just brought the hammer down in ways that were intrusive and violative of these victims' rights. And I tried to object, but most of the time the court would say it wasn't my place, because as we all know, prosecutors don't represent victims. They can't represent them ethically in any personal sense. They're just witnesses for us in our cases. So I would try, but get yelled at. And the last time a judge really called me out, I had again tried to say, Your Honor, you can't do that. You can't treat this victim in this case differently than you treat other victims in other cases. It's not right. And a judge pulled his glasses down off of his nose and said, Miss Murphy, you are the government. Your job is to state the law, not complain about it. If you want to change the law, you have to get a different job. So I took that challenge seriously. And when I left the DA's office pretty soon after that, that's exactly what I did. I said, well, okay, I see all these problems in the law that need fixing. I see no one doing anything. So I think I'll just step up and see what I can do. And of course, I told my husband at the time, I'm just going to do a little pro bono work for a while, like a year or two, and then I'll get a real job. And, here we are, I don't know how many years later, and I have yet to get that real job because there's just so much work to do and there's so much injustice. It's hard to walk away. It's really hard to walk away. And frankly, things have gotten a lot worse in my years since the DA's office. So the first case that landed on my desk that I was really excited about, the one that you just mentioned, was going to be the first time that a private attorney, which I was at the time, but with pretty good knowledge about how the system works, I was going to represent a victim to enforce her right, which was one of the earliest rights that most states adopted, a right to a prompt disposition. In this case, the victim's rights, in my opinion, were violated because the disposition in her case was not prompt, and I'll explain. The woman's name was Deborah Hagan. And when she came to me, it was because she said, I don't know if I have any rights, but this doesn't seem correct to me. I testified 13 years ago in a rape trial. I was brutally raped at knife point by this man who was known to us in our family. He was like a godfather to her. And she was attacked by him, brutally raped. The case was filed and it went to trial. And on the day of trial, the victim testified. The jury found him guilty. And at the end of the court hearing that day, after the jury found him guilty, they were proceeding to sentencing. And the judge said, we're going to move to sentencing, and I'm going to recommend a sentence of prison. Of course, it was such a serious crime, and the defendant pretended to have a heart attack, and he just fell over in the courtroom. Clearly was not a real heart attack, but the ambulance came, took him away, and he landed in a psychiatric ward, not a cardiac ward. No surprise. But the weird part was that the judge said, when you get out of the hospital, you come back and you're getting sentenced and you're going to prison. And he just never came back. And the victim, over the course of 13 years, would write letters to people saying, to the judge and the prosecutor, like, is anything going to happen? Like, I've seen this guy around. It's been 5 years, 10 years, it got up to 13 years. Is anyone going to do anything? He's been convicted of rape and he's never, ever been punished. And so when she kept getting the runaround from the DA's office, especially, she finally got a tip to call me, which is, it's so funny how people find me. It's usually from someone in the system, but they always say, call Wendy, but don't tell anyone I sent you. So that was a good sign, if you ask me, that I knew it was a good case. And I said, I'd be glad to help you. This is exactly the case I've been looking for, to sort of test the Victims' Bill of Rights laws and see whether they actually mean what they say they mean. I'm reading this law. It says you have a right to a prompt disposition. 13 years is not prompt. We win, right? So I went with her to court. I had to, which is often the case in my work, I had to create the motion that I was going to file out of whole cloth because no one had ever done this before. People probably know this, but as regular lawyers doing regular work, you can almost always find a form somewhere in the back of the law books, or you call a friend who's filed something that you're looking to file, and you can just replicate what someone else has done. Not true for some of this victim rights stuff, because there isn't a lot of systemic support for what victims need. So this was real creative lawyering, like blank slate stuff. And I wrote this motion to enforce the victim's right to a prompt disposition. And when I filed it with the court, the judge said, I've never seen this before. Let's schedule it for a hearing. And at some point, a couple weeks later, we had a hearing. And I laid out all the facts, including the 13-year delay, and it was such a clear case. But now the defense bar found out about this. The criminal defense bar heard that this case was going on, and of course they were not happy. So all the powers that be from that side of things show up and file an opposition saying, Deborah Hagan has no standing as a victim. She has no standing to be heard. And I read it and thought, what? What do you mean she has no standing? The legislature gave her a right, and it is a right to a prompt disposition. It's a specific right. And when the legislature gives you a right, you have a right to be heard to make sure that it gets enforced when it's threatened or violated. So I kind of thought nothing of this. This is going to be silly. No one's going to believe this. She has no standing stuff, because the law was so clear. And I did my research, and standing law is very clear. If the legislature gives you a right, then you have a right to enforce it. But by the time we got to the hearing then on the issue of standing, I was like 9 months pregnant, and I'm in the courtroom arguing
with one of your 5 children, by the way. I left that out of your bio.
Yes, with one of my 5 children. I was quite pregnant, and I knew this was an important case, and I was doing it for free, and there was no way I was not going to pursue it. I had good pregnancies, so that never bothered me. But I go to the courtroom, and I'm standing at the table with my client, who was living in Florida at the time, so she flew up to be at this hearing. And I thought it was a bit curious that the prosecution and the defense sat together at the other table. That was not a good sign. It's not a good sign. And the judge has a hearing, and we're getting ready to make our hearings, I should say. And in comes the perpetrator, the rapist, comes into the courtroom in a wheelchair, slouched over, and looking very frail. And I thought, oh, this is the same guy that faked a heart attack. I think there's a pretty good chance this isn't real either. And nevertheless, we argue the case, and the judge yells at the victim from the bench that she was audacious for wanting this poor frail man to go to prison. And it was terrible that her case fell through the cracks, but why would she want this poor frail man to go to prison? I mean, it was really horrifying, actually, how off kilter this whole story was turning in. I'm like, what is wrong with this? Is Alice in Wonderland. Anyway, we left that day. I went home planning to lose because the judge was so hostile to us. So I started working on an appeal to the Supreme Judicial Court. And I was really going to be glad to get it out of Worcester County anyway, which is notoriously bad for any version of the word justice. So I start working on my appeal to the Supreme Judicial Court, and I get a call from a state trooper who said, I know you're representing the victim in that case. I saw the news story in the local Worcester paper, which had a front page picture of this guy in the wheelchair, and the headline said, why does the victim want this poor man to go to prison? And I was just so disgusted by how the whole story was being treated by everyone in Worcester. But this trooper said, I saw the story in the Worcester paper. That guy is not in a wheelchair. And I said, oh, I'm not so surprised. And he said, I saw him in court last week with his girlfriend. I said, will you give me an affidavit? He said, absolutely. So I start preparing my appeal to the Supreme Judicial Court. And meanwhile, I called my friend at the Boston Herald, Jack Sullivan. I said, Jack, I think I have a story for you. I need you to stake this guy out because, XYZ, I tell him the story. He loves the story. He stakes the guy out, and whatever he could get, I knew it was going to help us. And he found, not surprisingly, the guy was in his front yard, lugging big bags of trash, smoking cigarettes, weeding in the garden. Really great. And then the front page of the Herald said, why is this man still free? A very different story than the Worcester paper. So I filed my appeal to the Supreme Judicial Court. And again, there was this massive hostility in response, including from the prosecutor. And that hostility was basically framed as, who does this Murphy think she is, filing an appeal on behalf of a victim? Victims don't have any standing, and they certainly have no right to appeal a judge's decision about anything. Like, it's the fight. If a judge says a victim has no rights, that's it. You can't do anything about it. Well, needless to say, I don't take those kinds of decisions lightly, nor do I just obey when people say that's the way it is, because you can always file an appeal. You might lose, but you have to file. And because there was no automatic avenue of appeal for victims, I filed under what's called a special writ statute, which basically every state has this kind of thing that's related to our First Amendment right to seek redress of grievances. And victims have a right to use this, and I use it all the time. But basically it means that if there's no statute or rule that allows you as a victim to appeal, you just file under this writ, because it's like a catch-all that says, if you have no other rule or law that allows you to appeal, you appeal under this one. Because we want to capture all violations of rights that are worthy of judicial review. And so I filed under that and said, of course, this is worthy of judicial review. The legislature gave my client a right to a prompt disposition. This was not prompt. We win. And the judge is wrong to say that we have no standing to complain. So the case was first has to be reviewed by a single justice before it gets sent to the full court. And the single justice at the time said, because there was so much press by this time, there was a ton of press, because it was almost a battle between Worcester and Boston media. And the public was so outraged, especially once the Herald story came out. So the single justice was under a lot of pressure. And I got a call from the clerk that the judge wanted to have a hearing on either August 8th or August 22nd. And that those were the only two options. So I immediately write a letter back and say, listen, I'm due to give birth on August 13th. Please pick the 8th. I know I'll make it to the 8th, but I won't make it to the 22nd. Please pick the 8th. And both lawyers on the other side, including the prosecutor, said, oh no, we can't possibly be around for the 8th. We're just far too busy. So they, of course, demanded the 22nd, because they wanted me out of the case. They wanted to take the press out of the case. They wanted to keep the heat down. And of course, the court picked the 22nd. And I was in a little bit of trouble then, because the birth was moving forward. The date came, August 13th, no baby, 14th, no baby, and on and on and on. I get to August 19th and I still have no baby. So I called my doctor and said, this was a Sunday. Please, 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 can you induce me tonight, a Sunday night, so I can get out of the hospital Tuesday afternoon and get to the court Wednesday morning? And my doctor said, absolutely. Which, I mean, by then I was perfectly cooked, if you will. So it wasn't a health issue for my child. And I went into the hospital and literally induced the baby, and she was literally perfectly cooked at 7 pounds. I got out of the hospital Tuesday afternoon and brought her with me. I was still wearing my maternity clothes, went to the courtroom that next morning with the baby in tow and a couple of babysitters. The headline in the Herald that day said something like, lawyer to stand and deliver at the SJC. I mean, people were really interested in this case, and it deserved, and I couldn't just send someone else to fill in. I'm like working pro bono. I didn't have the way the others did. They could have sent other lawyers. I couldn't. So I was glad to do it, although I was utterly exhausted, probably hadn't slept in 3 days, because that's what happens with a newborn. And it was perfect. The case just went so perfectly because I was there. I was able to make my argument. The other side had really nothing much to complain about. There was twice as many media there, because now they were interested in the 2.5-day-old baby, in addition to the outrageous injustice that preceded the birth. So we had like this double amount of media attention, which really greatly helped the case along. It just, because it was embarrassing to the legal system. And eventually, so the end of the story is that we do end up winning, but it's kind of a backward win. And let me explain. We end up winning in the sense that he does go back to jail. He ends up getting sent back to jail because the public just will not have it. And while he was in jail, he did die. So he finally developed some kind of ailment that was legitimate after all these years of lying about how sick he was. He finally got into prison. He did serve a bit of time, and then he passed away. And the beautiful thing about the court decision is that although the court said, and you have to read all these cases so carefully to see how the court is sort of trying to hide the good parts of a case and, soft pedal victories for victims. It just happens all the time in my cases. And this was a perfect example. The court said the legislature, and I should just clarify one thing before I tell you what the court said. So the single justice, in the day that I went in with my newborn, did end up sending the case to the full court for review. And that hearing happened sometime later, but the bottom line decision from the full court was that a victim who is given a right by the legislature, in this case, a right to a prompt disposition, has a right to seek enforcement of that right. So basically they said that the trial judge who said we couldn't even be heard was wrong. That if the legislature says a victim has a right, then that means a victim can go to court, file her own papers, bring her own lawyer, separate from the prosecutor, bring her own lawyer, make arguments about whatever the right was. We know that victim rights laws today contain lots of other provisions besides just a prompt disposition. And the point is, if the legislature says you as a victim have a right, that comes with the right to be heard in court yourself, either alone or with a lawyer. And that includes filing pleadings, making your argument in a formal brief. This is my right, and this is not being respected, and I want it to be enforced. So that was a beautiful victory. And it was the first case in the country that said a victim under the Victims' Bill of Rights laws has a right to be heard. Now, what they also said was that didn't come with a right of appeal. And that's why there was a lot of negative language in the case as well, basically saying that Murphy, by filing under this special writ statute, acted beyond the authority that the legislature gave victims when they said they had a right. So you have a right to be heard at the trial court level, but if the judge rules against you, you can't appeal. So it was like a double-edged sword, but it was still terrific to have had the first case in the country literally say, because there was no intellectually honest way to say otherwise, but this literally, the court said, the legislature gave victims a right. And where there is a right, there is a remedy, meaning you have a right to complain about it in court, formally, with or without a lawyer, verbally or filing pleadings, but it matters. The fact that victims have been given rights as victims, it matters, and and they have a right to be heard because enforcement matters. It was a wonderful victory that was basically dismissive of what we had been hearing from the defense side and even from the prosecution side, and that was that yes, the legislature gave victims all these rights, but they didn't mean to give them meaningful rights. They only meant to give them these like oratorical rights, like the pursuit of happiness. We all have that. It's in the preamble, but it's not a real right. So you can't go to court if you're not happy and can file a lawsuit. So they tried to say that it was really nothing more than this, what's the right phrase? Just a gesture of kindness, not a real right. But the problem is they use the word rights. When you use the word rights, it is actually a right. And good for Deborah that she stayed with that case for as long as she did, because 13 years without justice, I mean, most people would have given up. And I really commend her for being so heroic and refusing to accept the answers she was being given from prosecutors and from the court, that there was just nothing they could do. There was something we could do, and we did it, and it was a wonderful victory.
Well, that's why we talk about in Marsy's law getting meaningful and enforceable constitutional rights for victims around the country, because like you said, to have rights written down in a Victims' Bill of Rights and in statutory rights, that's one thing. But I think, like you said, it's a little bit different when a victim can walk into a courtroom under the same linguistic umbrella, as you said, as the defendant does with constitutional rights, because it elevates their rights, even in the judge's mind. And quite frankly, it creates a culture in a state and in a country, if we could ever get federal constitutional rights for victims as well, which you have done a lot of things and written a lot about how the cases that you have participated in really can at some point reinvigorate the debate for constitutional rights for victims. And we only have a couple minutes left, but I wanted to make sure that we talked about, so many people talk about giving a voice to victims, giving a voice to victims. You have literally participated in a case where you gave a voice to a victim. And it was a 2010 case, and it was a woman who was a sexual assault victim, and she suffered from aphasia, which is the impairment of language affecting the production or comprehension of speech and the ability to read or write. Comes in all sorts of different levels. Sometimes it happens as a result of some brain trauma or stroke. And this woman was in a home, and she was sexually assaulted. And tell us a little bit about that case. We only have a few minutes left, and how you were able to bring her and give her the accommodations that she needed.
Yeah, I can. Do we just have till 1:30?
Yes,
Oh
but
boy.
you can go.
Oh man, so yeah, this woman's name is Ruby McDonough, and the short story is she couldn't communicate, but boy was she smart. And the defense attorney representing the man who sexually violated her argued that Ruby should not have a right to testify after the charges were filed, that the case should be dismissed because Ruby was incompetent because she couldn't speak. Ultimately, the court agreed that she was incompetent because she couldn't speak, but that was because the defense attorney was asking her questions at the competency hearing that she couldn't answer, like, tell us what happened. She could answer yes and no style questions, but she couldn't narrate. And basically, when the defense attorney asked her open-ended questions, he was exploiting her disability rather than accommodating her, which is what people with disabilities are entitled to. So when the court found her incompetent, again, this is one of those cases where someone whispered in her family's ear and said, call Wendy Murphy. And I was so delighted to get the case that I did something similar to what I did with Hagen. I filed an appeal. And I filed an appeal on the grounds that Ruby McDonough, as a person, a victim with disabilities, had a right under the Americans with Disabilities Act to be respected and accommodated for her disabilities, not exploited and mocked the way the defense attorney did, and the way the court allowed, and the way the prosecutor allowed. I mean, all three of them violated Ruby's rights as a person with a disability, and I threatened to sue all three of them. I was delighted to file an appeal, and eventually the case was heard again by the full Supreme Judicial Court. And the wonderful thing about the decision is, basically what I asked the court to do was reverse the ruling that Ruby was incompetent, declare her competent because she was competent, and allow her to testify against this monster who had sexually violated her. And require, not just that, require the lawyers in the case to only ask questions that Ruby can answer. In other words, forbid, as an accommodation for Ruby, forbid the lawyers to ask questions that she's unable to answer because of her disability. So no open-ended questions, no multiple subject matter questions, no complex questions. Allow her to testify by touching the body parts that were affected, or pointing at images. And those are reasonable accommodations for a person with a disability. While the defense bar went, again, ballistic, and the prosecutor too was against us. They said this would be terrible to let victims dictate how the questions are to be put to them, because the prosecutor and the defense, we want to decide what kinds of questions we ask and how we ask them. The defense bar was particularly annoyed. They didn't want their hands tied. They wanted to be able to say, tell us what happened, to someone like Ruby, because they wanted then to argue to the jury, see, you shouldn't believe her. She can't even answer a question. Whereas my argument was, no, that's exploitive. That's discrimination. That's uncivilized. You cannot do that to Ruby. That's unconstitutional. And ultimately, our case on appeals was successful. The Supreme Judicial Court reversed what the lower court did, reversed the determination that Ruby was incompetent, and remanded the case and said, not only will Ruby be allowed to testify, she will be allowed to testify in the manner that she can testify in. In other words, all the lawyers have to ask her only yes and no style questions, only questions that she can answer, no complex questions. Allow her to testify by using gestures and pointing. So the good news is, when the case got remanded, we were so delighted because the court was required to allow me to show up in court as the victim's lawyer, file pleadings, motion for accommodations on behalf of the victim. I was allowed to do all of this. I argued all the time in the case whenever we had anything to discuss about her accommodations. And then the defense was, again, just livid that anyone would let a victim or her lawyer even appear in court, much less file pleadings and say something. And the judge did try at one point to silence me. He said, Ms. Murphy, victims don't have standing. Because if you read the case that we won, the court spends a lot of time saying victims don't have standing, victims don't have standing. But what they really said, what the court really said, and you have to read the case carefully, they said victims don't have standing as a party. And I didn't dispute that. I said, I don't want to have standing as a party. I represent the victim as a non-party, as a third party. I don't want standing as a party. And as I advocated for Ruby and kept insisting that she had a right to be heard as a non-party, we kind of resolved the tension. But the judge tried to keep me quiet and kept saying, you have no standing. He threatened to put me in jail if I kept talking. I said, but I won my case. The Supreme Court ruled in our favor and said, Ruby can appear in court with me, file her own pleadings, ask for her own accommodations, and you will listen to me, Your Honor. You will listen to me. We do have standing to be heard, to be heard. And the judge eventually agreed, was extremely kind and generous to us after I fought him. And I mean, I fought him really hard. Eventually, he gave in, allowed me to do everything I could on behalf of Ruby. And Ruby did finally have her day in court. And the good news is the bad guy, his name is Kofi Agana, he spent 2 years in jail because of our appeal, because it took that long for our appeal to go forward. So, it was like the best form of justice. He probably wouldn't have served any time in jail if the case had just gone forward. He might have gotten, probation because it was a first offense. But because there was so much hostility toward Ruby and the fight was so vicious against her, just trying to seek to protect her rights as a disabled person, it ended up leading to the appeal, which delayed the case for 2 years. And he spent time in jail for 2 years. So it was just a perfect form of justice. And the best part of the story, as you said, Peter, is that here was I'd always talk about giving voice to victims, and we mean it metaphorically. This was a case where literally a woman with no voice got the court to give her voice in the most powerful way imaginable. She not only testified against the bad guy, she changed the law because it was the first case in the entire country where a person with a disability regarding her speech was granted accommodation rights. Before Ruby's case, the only rights victims with disabilities had was the right to a wheelchair ramp to get them into the courthouse. And that was good for Ruby. It got her in, but it wasn't good enough because it didn't facilitate her equal participation in our system of justice. Her case that we fought so hard for established that right in terms of communication disabilities and her right to communicative and testimonial accommodations. It was the first case in the country that said victims have this right. And as you mentioned, Peter, the court went out of its way to say, and this does not violate the rights of the accused. The defense attorney kept insisting, if you let victims do this and tell us how to formulate questions and how we have to ask questions of them, you're tying the hands of the defense and you're violating the defendant's right to a fair trial and right to cross-examine in whatever way they see fit. And the court said, oh, no, we're not. Oh, no, we're not. We're just telling you, you can't exploit someone's disability to win, that your rights, your due process rights, your Sixth Amendment rights are important, but they don't allow you to exploit a person with a disability. And when did you ever think that's what the Constitution allowed? So this is a wonderful example of a court saying, just because you give rights to a victim doesn't mean you've weakened the rights of the accused. They're both important and they both have to be respected. And that was a brilliant point on the part of the court that I had never seen any court say before, ever.
Yeah, no, it really was your advocacy and Ruby's bravery that made this a case that has been written about, that has set forth the guidelines where a witness seeks accommodations for a disability in order to testify in a criminal case. And when you said you have to read, I read the Supreme Judicial Court opinion, and I read some of the language that talks about the way that these cases are going to be treated going forward. Because of their vulnerabilities, this is the court, persons with disabilities may often be crime victims and their interests need protection no less than other victims. It is incumbent on all judges and judicial staff to ensure that every person with a disability be provided with reasonable accommodation, if available, to ensure that she can be a full and equal participant in our system of justice. And that was because of your advocacy. I say it to people when people say, describe Wendy Murphy to me as a victims' rights lawyer. I say, you really have to see her in action to understand that she is the same person that could, with one hand, throw the equivalent of a legal knockout punch, and with the other hand, have us softly on the shoulder of a victim who needs it more than anything in the world. That's an incredible talent that you have. And when you talked about giving a voice metaphorically, which you always do, but literally in this case, there was a woman that suffered from aphasia who wrote something about this case. And she ended by saying, "Thank you, Ruby McDonough, for finding your voice." And that was because of you and your persistence. You didn't back down. And it really is incredible what you've done. You've given voice to her, literally and metaphorically, to victims. You continue to do it all around the country. Wendy, thank you so much for taking some
Thank you,
time.
Peter. Thank you for those nice comments. There's always more work to do. And the good news is, even when you just win a little bit of something in a case, it gives us hope. And that's what victims need.
Really appreciate it, Wendy. Have a great day. Thanks so much for joining us.
You too. Bye-bye.